Good day, citizens, and welcome to this podcast edition of the Thomas Jefferson Hour.
Impeachment, 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 impeachment.
And Mason, you probably are staying up too late, and you don't need to hear all this anyway, right?
So the question is, what did the Founding Fathers intend by the impeachment clause of the Constitution? I think it surprises some to know that it doesn't just involve presidents. Other national officers can be impeached. And in Jefferson's administration, two were impeached. Judge John Pickering of New Hampshire, who was an alcoholic and insane by anyone's measure, and then Justice Samuel Chase of the Supreme Court, who was a ruffian and a browbeater and a bully, and he was acquitted.
And both appointed by President Washington, correct?
That is correct. Jefferson appointed three to the Supreme Court. They all wound up disappointing him in one form or another. But what these programs really teach me is that we've had four impeachment episodes with respect to the presidency: Andrew Johnson, Richard Nixon, William Jefferson Clinton, and now Donald Trump. Just four out of the 45 presidents, and Nixon was never impeached. He was going to be, and nobody has ever been removed by the Senate. So it's a very, very rare thing and an incredibly high standard. It takes 2/3 vote in the Senate. That's 67 under our system now. And getting 67 senators to agree on something of that gravity is essentially an impossibility.
But it should be that difficult, and it shouldn't be as simple.
Well, it shouldn't be so difficult that it never will happen. In other words, that's the whole problem. It's like you want the amendment process to be difficult, but you want it to happen. You want the impeachment clause to be very difficult ever to enforce, but you want it to happen sometime.
But as I talked to Jefferson about this, and he acknowledged after the trial of Samuel Chase. And by the way, you shared the greatest story at the end of the show.
Aaron Burr story is
the Aaron Burr presiding over the trial. I don't want to give that away. Yeah, but Jefferson acknowledged that Samuel Chase's trial had an effect. It set a precedent.
It chastened the court.
In fact, William Rehnquist wrote about it in his book.
So even though the impeachment failed and Chase was acquitted, the sense by historians is it had a chastening effect, and the judicial branch realized we better bring it down a little here. We better be a little more temperate.
So it did have an effect. So maybe they didn't succeed in removing him from office. And as we talked to Jefferson, I kind of was hammering at him, talking, like asking reporter questions about, well, yeah, you did this and you did this and you did this. It had an effect, even though they didn't remove him from office.
Well, and it's very complex, and I can't go into all the details, but
you do in the show, though.
A couple of things we didn't get into the program. One is that the prosecutor in the House was John Randolph of Roanoke, Jefferson's cousin, who was crazy. He was a weird, powerful, neurotic, tightly wound, irascible, outspoken person, a radical Republican who found Jefferson way too moderate. And he presided. He was the prosecuting member of the House of Representatives, and he nearly had a nervous breakdown over it. And he would speak for like 4 hours at a time. His closing summation was 2.5 hours.
You've watched enough of these impeachment hearings now that there's a couple of folks who
get close to that. But on the other hand, John Randolph was one of the most brilliant men in the history of the United States Congress. And so I would love to have watched him, because he was apparently he was like Uriah Heep and Dickens. He was just rail thin, this kind of eel, this human eel, and he had this high-pitched, squeaky voice, and he wore boots and spurs into the House of Representatives and the Senate, and he brought his hunting dogs in with him to the Capitol at times. He was a genuine eccentric, and he handled it, and he didn't handle it very well. And on the other side, there were 5 of the most brilliant Federalist lawyers in the country defending Samuel Chase, including Luther Martin, who was called the Federalist Bulldog. And apparently he was so sarcastic. He had them laughing in the Senate, and he had them, shouting acclaim, and he shocked them with his rhetoric. And apparently he was just 100% the perfect defense lawyer for Samuel Chase. Chase himself gave more than a 2-hour deposition in which he defended his actions. Anyway, Jefferson had a solid majority, a 2/3 majority in the House and in the Senate voted to acquit Chase on all 8 articles of impeachment. Jefferson was so disappointed. He thought, wow, where's your party discipline when you really need it? But
yeah, he probably would have gone after Marshall, too, though, if he'd have won.
It's an amazing, yes, of course. It's just one of the great stories. And to think of Aaron Burr presiding over this and John Randolph of Roanoke. Jefferson, of course, stayed over at the White House pretending he was above it all, as usual. But it's one of the less well-attended to great episodes of early national history. And you know what I would love to hear is Joseph Ellis talking about this, because you know that he would bring...
it's about time to call him.
We should get him involved.
Yeah, I bet he knows a lot.
Bring some color into this story.
Yeah, that
because
would, too.
if we had a videotape of John Randolph, I'd give anything for it.
Somebody ought to write a book about that.
No, I mean, talk about a miniseries. It would be superb. And you know, the reason that we're having this conversation at all, David, is that those 4 outstanding constitutional law scholars on the 4th of December were testifying before the House of Representatives Judiciary Committee, and they were just drop-dead brilliant. And it was a lesson in civics. They were quoting the Founding Fathers and talking about the Federalist Papers and Madison and Jefferson's correspondence with John Adams. And I just thought, this is the America I want to live in. I wish it were a little more high-minded more of the time. But that is a useful civics lesson that we got on the 4th of December. So now we're talking about these 2 very important impeachments that occurred during the Jefferson administration. One succeeded because Pickering really had to be retired. The other one failed when Chase was acquitted.
It's time for us to go to the show, but I want to give you the opportunity. You've got a show coming up at the Roper Theater.
Yeah,
that
the
I know
25th of February.
Very important.
Try to keep
you.
a straight face. This is my comedy show, one-man monologue of humorous stories.
Oh,
the famous
keep a
pickle
straight
story.
face like everybody in the audience?
Yeah,
will? That kind of thing?
Great. You're going to be so sorry when the album comes out and it goes viral. I'm
sure,
going to be at the Grammy Awards saying, I want to thank the Academy.
I'm sure it'll be great.
I want people to come to this. I need 500 or more people to be in the Roper. I'll tell you what.
It's hard to get something submitted to the Grammys.
You will laugh
this.
out loud.
I've been a member of the Academy for well over a decade.
Out loud when this is released.
Close to 2.
I have lots of funny stories about my wayward life as a man who dresses up like dead people.
You know I have 2 Grammy nominations.
The TSA, yes,
right?
I know, but you go ahead and step all over my advertisement here.
Working on it.
Yeah, so that's on the 25th of February. Please, please, please go to the website and come to that, for me, very important event, whatever you might think.
In all seriousness, I'm sure it'll be great.
And then this summer, the Lewis and Clark Cultural Tour. Once again, the 18th annual Lewis and Clark Cultural Tour on the wild and scenic Missouri and up the Wendover hike and camping under the pine trees.
I'm excited for you for both of those things, but I'm much more excited for your daughter who is coming back for the holidays. And we need some emails from people, again, encouraging her to be on the show.
She'll be respectful about this comedy program.
Oh, yeah.
Yeah, she said, what are you, William Shatner late in your career, Dad?
Yeah,
it's going to be, great.
Okay, so
25th of February.
Go to jeffersonhour.com. You can find out all the details about all of this.
So laugh a minute, folks.
And support the show, and we really appreciate
we need that too, but yeah.
Happy holidays to everyone.
Happy holidays.
And off to this week's Thomas Jefferson Hour. Good day, citizens, and welcome to the Thomas Jefferson Hour, your weekly conversation with President Thomas Jefferson. Mr. Jefferson is portrayed by the award-winning humanities scholar and author Clay Jenkinson. I'm your host, David Swenson, and seated across from me is Mr. Jefferson, and good day to you, sir.
Good day to you, citizen.
Mr. Jefferson, the United States public is pretty wrapped up in what has become an impeachment hearing. I don't really want to talk to you so much, sir, about what's happening in America today, although I certainly would welcome your observations and comments, but I was hoping we could talk about impeachment during your time.
I was the President of the United States for 8 years, 2 terms, between 1801 and 1809. I was the 3rd president, and there were no serious calls for my impeachment. But during my 2 terms, we did impeach 2 officers of the court, a judge in New Hampshire of the federal court system and a Supreme Court Justice, Samuel Chase. One of those ended in removal from office in the case of John Pickering of New Hampshire. and the other ended in acquittal in the United States Senate. That was the impeachment under 8 charges of Samuel Chase of Maryland.
These were not the first impeachments. In fact, the first impeachment occurred in May of 1796 of Mr. George Turner.
Yes, but these were before my own time, and I can tell you this as a matter of history. Up until your own time, there has never been a successful impeachment and removal of a Supreme Court justice in American history.
And why do you think that is, sir?
I think that impeachment is a very grave matter, that we tend to err on the side of acquittal, that the Founding Fathers set a very high bar for removal from office, 2/3 of the senators, and that 2/3 is an extremely difficult consensus to reach at any point in American history. I think probably if you could look down on American history with completely objective eyes, there must have been a number of presidents and a score or more of Supreme Court justices who richly deserved to be removed from office and weren't.
I'm not certain that American citizens today understand impeachment. I think because of the times we live in and the news we read during my time, sir, I think most people associate impeachment with the president and the president only, but that's not accurate.
No, any national officer may be impeached.
And the first that was impeached or held up for impeachment during your presidency was a Mr. John Pickering. You mentioned him, from New Hampshire.
John Pickering was a lawyer from New Hampshire. He was a well-regarded man, an important man. He had helped to draft the New Hampshire Constitution after the War of Independence began. He was a good patriot. His family appreciated and respected him. He was a solid, even exemplary citizen in New Hampshire.
No, he was actually impeached, if I'm correct, on 4 different articles, and was removed from office in March of 1804 during your presidency, right?
That is correct. So here, let me tell you what happened. I did not know him personally, but the word came to me from New Hampshire that he was debilitated by alcoholism, that he had a very serious problem with alcohol, and that it affected his work on the court, and this is harder to ascertain in any measurable way, but he was widely believed to be insane, and not just mentally unstable, but insane. He raved from the bench. He shouted expletives at opposing counsel. He didn't always turn up for court sessions.
Goodness, how did the man get appointed, sir?
He was appointed during the Washington administration, and this is one of those situations where it was already known that he was unstable, and he was sort of kicked upstairs by the people of New Hampshire, and they urged General Washington to appoint him to a federal post, a federal judicial post, and Washington did. This did not solve any problems, of course. It only made them worse, but this took this out of the state world of New Hampshire and placed it firmly within the federal judicial system of the United States. This went on for a long time. When I became president, I was aware of this, and the question was, what do you do when there is a national officer who has not committed any crimes, has not taken bribes, has not committed treason? There are no misdemeanors that can be fixated on him, and yet he must be removed for the good of the Commonwealth. What is the procedure? And the fact is that there isn't a useful procedure. And here's what I attempted to do. I didn't want this crisis. I'm a harmony lover. I wanted to be a conciliatory president of the United States. If you read my first inaugural address, you see that I say we are all Republicans, we are all Federalists, and every difference of opinion is not a difference of principle. I did not seek this out, but something had to be done. And so I thought that the best solution would be for us to approach the family of John Pickering and say, look, you know this is a problem. You know he needs to be removed from the bench and treated with the greatest possible affection and love within the boundaries of his own family. Help us to convince him to retire voluntarily. This will solve the problem and will save his dignity, and it will prevent this from becoming a partisan nightmare of some sort. And so I didn't approach the family, but people in New Hampshire who were very generous individuals did. And the family refused. The family said, no, we're not going to do that. So now I didn't know what to do, because I certainly believed that he needed to be removed from the federal bench. He had not committed any impeachable offenses. So there's no answer to this. And so what we did was allow 4 charges to be put forward against him, none involving insanity, a few involving alcohol. And he was, on a strictly partisan vote, on March 12, 1804, removed from his federal position and retired into private life. But even at that time, and this was a very good solution to the problem, that he had to be retired, and we saw to it that he was retired. But even at the time, I felt very unhappy about the way it was done, because the impeachment clause does not have enough elasticity to cover this problem. And we had to then stretch the impeachment clause in a way that it was never intended, I feel certain, to cover insanity and alcoholism. And in doing so, then you have damaged the rule of law to a certain degree.
I was going to ask you, sir, about a president's official involvement in impeachment. Your wish for harmony noted. But the historical record tells us that on February 4th, 1803, the House received a report from you, sir, regarding the conduct of Judge Pickering.
Yes. I repeat, it was important that he be retired from the bench. And after our informal approach to the family failed, we were left with no happy choice. And the one we chose, as I have admitted, was a bungling way. And I felt that it was a highly imprecise tool, and that it strained the clear meaning of the Constitution.
I'm just curious, sir, the mechanics of this. Does a president need to be the one who begins these impeachment inquiries? Anyone can do it? Or
yes, there's no formal process. In other words, the president does not have a constitutional duty to bring the attention of the House of Representatives to this issue.
So any member of the House could have asked for this to be reviewed. Is that right?
A citizen of New Hampshire could have said, we need you to look into this.
I did not know that, sir.
A complaint could have been lodged. No, the president has nothing to do with this. The president is, unless the president himself is being impeached, the president has no constitutional, no formal role in this process whatsoever. It entirely belongs first to the House of Representatives, and if the House votes impeachment articles, then it goes to the Senate. The Senate sits as a jury. One would hope an impartial jury, weighs the facts as they are presented to it, and then votes and must vote with a 2/3 majority to remove a sitting national officer.
Now, you had said that he was appointed by President Washington, and
that is correct.
I'm curious, was Pickering, was he a Revolutionary War hero? Was he a very successful businessman? Was he a government servant? How did it come about that Washington appointed this man?
He was a solid jurist, a good lawyer, well-educated. He had established himself as an important figure in the judicial circles of New Hampshire. When a president names a judge or a justice, he has a district in mind, a part of the geography of the United States. So George Washington needed to have judges, federal judges from that part of the republic, and he then consulted with the senators and representatives of the state of New Hampshire and said, give me advice so that I can appoint the right person. And it was then that even though people knew that there was a Pickering problem, they nevertheless put his name forward to President Washington. President Washington nominated him. The Senate had to approve of that. The Senate sits in judgment of judicial appointees, and they approved his nomination.
And this impeachment was a long process. It took, from my estimation here, about 13 months to complete.
Well, nobody wanted to do it, and we understood that the impeachment clause didn't cover it. And so in the end, we had to do it. We sort of had to hold our nose and use the imprecise impeachment clause of the Constitution to do something that it was not really equipped to do, but the Founding Fathers had not given us another mechanism, and he wouldn't resign. And so they left us no choice. I suppose we could have shrugged and said, eventually he will die or retire from some infirmity or other, but that's not really what you want in a Republican system of justice.
Thank you, Mr. Jefferson. We're going to take a short break. When we return, sir, I would like to talk to you about another impeachment case, that of Samuel Chase, sir.
Oh my, that's a much more difficult one.
We'll be back in just a moment. You're listening to the Thomas Jefferson Hour. Welcome back to the Thomas Jefferson Hour, your weekly conversation with President Thomas Jefferson. This week we're talking about a couple cases of impeachment, Judge John Pickering, and when we took our break, I was hoping that we could move on to Judge Samuel Chase, a Supreme Court justice.
Yes, I should say one more thing about the Pickering case. There was no dispute about his infirmity. There were no defenders of him against the charge of alcoholism and mental instability. It's not as if these were contested points. And here's what really struck me as sad. When the vote finally came in the Senate, it fell out on strictly partisan lines. The Republicans, my party, voted for removal, and the Federalists, even though they knew of his problems, voted to acquit.
Oh, how do you account for that, sir?
The Federalists were angry with me for being elected. They were angry with me because I had repealed the Judiciary Act of 1801. So
people should understand that you were not just elected. You were elected by what we might call today a blue or a red wave.
Well, there was an anti-federalist feeling at the time, largely because of John Adams' mishandling of the war crisis with France and because of the Alien and Sedition laws, which were palpable violations in 1798 of the Bill of Rights to the Constitution of the United States. These were laws worthy of the 9th or 10th century.
So this propelled you to a majority, and you could sort of do whatever you wanted, sir.
Well, not quite. The vote in 1800 was more, I believe, a vote of no confidence in federalism, and particularly federalism as it was being handled by John Adams, than it was an endorsement of me. But I did win, and I soon had control of both houses of Congress. So I had a friendly House and a friendly Senate. And it is, I think, the case, and I know this will sound prideful, I hope it doesn't, but from 1802 until 1808, I essentially got everything that I wanted from the Congress of the United States. I merely had to make a hint at a dinner party or call somebody aside for a short, casual conversation, and Congress would line up and do whatever I pleased.
In your defense, if I may, sir, you accomplished a great deal and a great deal of good for America. I know you have said in past conversations the retirement of America's debt was one of your great accomplishments.
Well, there's that. I retired 37% of the national debt of the United States by the strictest fiscal rigor. I mean, a very unpleasant thing to do, but I pared down the size of government to its sort of statistical minimum and starved a whole series of things that I would have liked to have funded. But I felt that national debt is a disgrace, and it's a way of taxing the future without its consent. And so that was my primary commitment as president. But I also made the Louisiana Purchase as president. But I was able, in very careful, nuanced hints, to make it clear what I hoped that Congress would do. And then these legislators would go back to the Capitol and almost invariably enact into legislation the things that I had informally hinted at. So I was fortunate in that respect. But you asked, why did the Federalists vote to acquit John Pickering when even they acknowledged that he was a very, very troubled human being?
We've established, sir, that you had a majority, as you said. 2 years into your presidency, your party had control of both of the houses, which brings me to the point of Samuel Chase. He was a Federalist, and it is said that you considered him probably the most dangerous justice on the court. He had not a stellar record. He is known to have bullied Quakers for their pacifism. I think during the war, he cornered a flower market for personal gain. So there's a list of things that he did. And then I come across the fact that he was also a judge in the trial of James Callender.
Well, he was the judge in trials that had a personal connection to me, two of them. One was Callender, and Callender, remember, was that British-born journalist, sort of rabble-rouser, muckraker, who came to this country just before the 1798 crisis, the quasi-war with France. And I met him in Philadelphia, and he wrote some pretty violent attacks against the Alien and Sedition laws and against the Adams administration, and I must acknowledge against Adams himself in an ad hominem way. And he was a kind of a anti-federalist bulldog amongst newspapermen. And I will say, in retrospect, what I would never have admitted in my own lifetime, that I encouraged him to a considerable extent and gave him small amounts of cash, and I subscribed to his pamphlets and got others to subscribe to him, and I felt that he was an important figure in the criticism that was required of the Adams administration and its actions. And so I know that puts me in a somewhat negative light, and as you know, after he was jailed by Samuel Chase under the provisions of the sedition law, Chase was riding circuit. He was the justices of the Supreme Court back then had to ride circuit and take routine cases, and he presided over the Callender case, and he bullied Callender and actually gave him a stiff fine and a jail sentence. And when I became president then, on the 4th of March, 1801, one of the very first things I did was to free everyone who had been jailed under the sedition laws, which I considered to be unconstitutional in a fundamental way, and I had their fines remitted.
Yes, sir. I've always admired that action.
And I think I did the right thing.
I think you did too.
But Callender was an ingrate. He now demanded that I give him a plum post. He wanted to be the postmaster of Richmond in Virginia. He was, of course, not qualified for that post. I did not reward him with that post. He became disenchanted with me. He began to threaten me through my agents, particularly Meriwether Lewis, who was then my private secretary, saying that he had information which he would divulge if necessary to shame me and to bring scandal to my administration. And he hoped that this would lead me to give him a sinecure, a job without any particular duties, so that he could, I suppose, live to write more scurrilous journalism. I refused, and when I did, he broke the Sally Hemings story in September of 1802. So the Sally Hemings story that you all know, and which has become a kind of a historical orthodoxy in your time, was news in 1802. The rumors had been circulating for years around Monticello, but the first time the nation heard of the Sally Hemings story was in September of 1802 by this journalist, James Callender, who had once been my ally. So Chase presided over that trial.
Well, I think that's important to recognize. I don't want to get into that. It would be a deep well we would fall into and never come out of, sir. But I do think it's important to understand, the times then. It is said that you were alarmed at the seizure of power by the judiciary because of the claim of exclusive judicial review. And Congress helped alleviate that. Am I getting it right?
Well, there are a couple of things there. So there are three branches of our national government. The executive branch, that's the president and his cabinet and so on. the legislative branch, the House of Representatives and the Senate. That's the most important branch, of course, in a Republican system. And then there's the judicial branch, the sort of the least important of the three branches. And if you read your Constitution, you will not find the doctrine of judicial review in it. It's never mentioned as a constitutional power of the federal judicial system. Judicial review is that power that the judiciary has to strike down, to veto acts of Congress or deeds of the executive. It wasn't debated at the Constitutional Convention. There's no clause in the Constitution that can be read as a justification for judicial review. It was imposed on the Constitution in the spring of 1803 by my cousin John Marshall, the Chief Justice of the Supreme Court, who in the case Marbury v. Madison actually traveled out of the case and lectured my administration about what it should have done with respect to certain U.S. Marshals and so on that were appointed in the last hours of the Adams administration. And it was in that famous decision, Marbury v. Madison, that Chief Justice Marshall said that the judicial branch of government had the right and the duty to review acts of Congress and to decide which ones of those acts were constitutional and therefore legitimate, and which ones violated provisions in the Constitution and were therefore void. That upset me, of course, because I think that is too much power in the hands of unelected people, especially as it was not contemplated by the founding fathers in Philadelphia in 1787. So there's one issue that I had. And secondly, when the Federalists lost power in the election of 1800, which I called the Second American Revolution, when they were discredited and retired, in the lame duck session of that Federalist Congress, they passed the Judiciary Act of 1801, which was not passed for professional reasons. It was passed to pack the courts with known enemies to my vision of this country and my administration. So as the Federalists had been retired in the election of the autumn of 1800, they met one more time as a lame duck Congress, and knowing that they were going to lose the House and the Senate and the executive, the two branches of government, they threw all of their weight into the third branch, the judicial branch, and packed it they increased the number of judgeships, they relieved justices from riding circuit, and they filled all of the vacancies, some of which they created, with known enemies to my view of this country, people that would be life tenured, and their work would be to prevent the Second American Revolution, which I represented, from flourishing, from bringing about a restoration of the principles of 1776.
So we have established then, sir, that there was a concern amongst you and your supporters that the judiciary was becoming too strong, and you wanted to somehow offset that. Is that correct?
Not just too strong, but openly, nakedly, unambiguously partisan as a sort of final redoubt, a final bastion of federalism that would do whatever it could to protect the Federalist Party's views of things and to prevent the sort of reforms and the democratization of this culture that I had in mind. And so one of the first things my Congress did when it met was to repeal the Judiciary Act of 1801.
Sir, don't take my questioning as being accusatory in any sense. I'm just trying to understand. But, in the case of John Pickering, as you have said, this man was mentally and physically incapable of discharging his duties of office.
You are correct, sir.
In the case of Samuel Chase, at quick reading of it, it would seem that there were differences in policy that you and your supporters took to be more than just differences, but outright, I'm not sure what the word is to use, sir.
Well, I can tell you this, and I'll try to be scrupulously accurate and fair so that nobody could charge this with being a partisan indictment.
Which could easily be done.
Of course, and I understand that. He browbeat grand juries. He bullied defense counsel. He gave instructions to the jury that essentially forced the conviction of people like James Callender and also the other one that had a connection to me, Thomas Cooper.
It sounds more like a defense attorney than a judge.
He intervened in the process. His instructions to juries often prevented them from deliberating in an open way about the quality of the evidence and the law that was being applied. He also gave wild speeches from the bench, particularly in a Baltimore moment where he denounced me, he denounced my administration. He said that we were heading towards mobocracy and that the anarchy was coming, that all of the social controls that made a society worth living in were being torn down by these Jacobins and these freethinkers and anarchists and so on.
Mobocracy was not a light term during your time.
No. So he's using his power not to be a neutral justice to make sure that the rules of procedure are adhered to and that everyone gets a fair trial. He's using this very important privilege of being a justice of the Supreme Court of the United States back when there were only 5 or 6, not 9. He's using that power to browbeat jurors, to force certain convictions, to belittle the process, to attack the existing administration, to bully anyone that wasn't looking at things the way he, as a Federalist partisan, was looking at them. There's no question in my mind that this was not what the Constitution had in mind when we created justices of the Supreme Court. Whether he committed any treason, bribery, high crime, or misdemeanor, of course, is another question, and it points again to the inadequacy of the impeachment clause of the Constitution.
I took the time to look up the 8 articles of impeachment against Mr. Chase, and number 8 was directed at his, quote, intemperate and inflammatory, indecent and unbecoming, highly unwarrantable, highly indecent remarks.
Yes, it's certainly true. Now, but here's the problem. Okay, we get it that he was obnoxious. We understand that he was a bully. We see that he was using his office to make wild political attacks on people whose vision of this country he despised. Those are horrible things, and a person like that does not have the judicial temperament to be a Supreme Court justice, of course. There's no crime in being a shameless bully. So the question is, what do you do about this? And we all understood that we were straining the impeachment clause to try to evict somebody who probably should have been retired from the bench, but who was not a criminal. He had not committed treason against his country. And so this is the problem. And I just to jump ahead, I will tell you that when the Senate voted, and it was a Republican Senate, I had a solid majority in the Senate, they did not convict him on any one of the 8 charges in the articles of impeachment that had been leveled against him. He was nearly convicted on, but not, and others he wasn't even partially convicted by a Senate that was dominated by men of my own party. So this was a very considerable political setback to me, and it was it proved once and for all that the impeachment business is not an effective way to get rid of somebody whose malfeasance is clear but who has not committed an actionable treason against his country.
Well, it did have an effect, sir. According to a Chief Justice of my lifetime, William Rehnquist, for their part, federal judges since that time have generally been much more cautious than Samuel Chase in trying to avoid their appearance of political partisanship.
You are correct, sir. And you know, John Marshall.
It did have an effect.
Justice Marshall was one of the 55 witnesses in the case brought by the prosecution, and he was very timid and very cautious and very conciliatory in his deposition and in the cross-examination that occurred in the impeachment trial, because he knew that if he did not show some conciliation, that we would get more serious about removals, and that he had to meet us halfway and to admit that Chase's behavior was unprofessional and unacceptable, even if it was not subject to an eviction.
Thank you, Mr. Jefferson, for a very enlightening conversation, one that I think we can all learn from during my time, sir.
You are welcome, sir.
We're going to take a short break, but we'll be back in just a moment. You're listening to the Thomas Jefferson Hour.
Welcome back, everyone, to the Thomas Jefferson Hour. I'm Clay Jenkinson, now safely out of tights and wig. And across from me is the semi-permanent guest host of the Thomas Jefferson Hour, Mr. David Swenson.
Yes, here I am. And, we've had 2 weeks on impeachment. And
there'll be more, I'm afraid.
Yeah, well, we're recording this. We don't really know what's going on currently because we're pre-recording this. We have getting exciting news. You're just in a flurry because your daughter is coming home for Christmas.
Yes, the other occasional guest host of the Jefferson Hour is coming back from Oxford.
You need to be very nice to her and talk her into doing the show.
Hey, maybe she should be nice to me if you think about it. She's a little snarky when she's on this program.
I like it, and so do listeners.
But she's coming back, and I can't wait to see her. She has successfully gone through her first term at Oxford. And in fact, on the day that we're recording this, she had her review, and it went very well. She's coming home now for about 5 weeks.
Well, we look forward to that. Before you get in, I know there's some things you want to touch on, but before we go there, may I?
Yes, sir.
The last 2 shows, as we said, have been about impeachment. But I'm very proud that we have not done the usual or obvious thing. We offered perspective, but not a final opinion on it. And I think that's what we should do.
What surprised me in preparing for these programs is that I found myself more cautious about impeachment than I thought I was. And I have great concerns about this impeachment. I don't think it's possible to really chart my political views from the analysis that I have provided. It's the most honest one that I can, trying to ground it in the historical record, and particularly that brilliant testimony by the 4 constitutional scholars on the 4th of December before the House Judiciary Committee. It really set me to reading and to thinking, and I propose that people read some books on this subject. There are 4 or 5 of them out now about the impeachment of Donald Trump. Some are pro-impeachment, some are anti-impeachment, and several are just historical. So let me say this much more about the Chase trial. So the Pickering trial is clear. So, what the Pickering trial tells us, when the insane and alcoholic John Pickering was finally removed in early 1804, is that the impeachment clause of the Constitution has a really serious and potentially fatal flaw. It doesn't have a mechanism for removing John Pickering. The only way you can use the impeachment clause is to strain it, and that creates a crisis of conscience for those who vote to remove, and it creates a defense for those who want to protect.
I keep hearing that it is entirely up to Congress. They make the rules, and they can pretty much make the rules in whatever way they see fit.
Yes, but you see what's happening in this case, that the defenders of President Trump are saying, we're looking at this impeachment clause, and we don't see...
But that happened with Samuel Chase, too.
It happens all the time, which is my point, that the Founding Fathers should have provided a clearer path, a recipe for this.
Democracy is messy.
It is, but that doesn't mean that they couldn't have done a better job of it. And if Jefferson's right and we revise the Constitution, we should address this issue. So that's Pickering. So...
Yeah, but even still, it's like, okay, bribery is a crime. Well, look what happened with the 4 constitutional scholars. There was, I don't know how much time, but a considerable amount of time just defining that word, that crime.
Because bribery, for most of us in our common sense approach to life, means something else. Bribery means that Becky gives $500,000 for her daughter to get into USC. That's what bribery is regarded as by most people. And so whatever Donald Trump has done is not a bribe of that sort.
Yes.
So here's what's so interesting. We didn't talk about this in character, but this is a delicious story. It deserves to be a mini-series. Who presided over the Senate trial of Samuel Chase? None other than Aaron Burr, who had recently killed a man in a duel. And the man that he recently killed in a duel was Colonel Alexander Hamilton. So here's the man who murdered Hamilton, who has been indicted in New Jersey and New York, who is now presiding over the impeachment of Justice Samuel Chase of the Supreme Court of the United States. And one of the Federalist wags who was there said, normally it's the justice who presides over the murder case, but here we have the murderer presiding over the case of the justice.
And we think we live in strange
So
times.
think of it. If Vice President Pence had killed someone in a duel, and then he's called in to preside over this case, which is what happened in the situation with Burr. And Burr, this was his last act because he knew his political career was over. Jefferson had dumped him like a hot potato in the 1804 election. He ran for governor of New York and lost. He killed Hamilton in the duel. He's really
done.
He's flamed out. He's what's left is treason in the American West, but he's done politically. So this was his last hurrah, and he took it so seriously, David. He had the galleries set up so that 1,000 people could come and watch. He had red baize, red cloth put over the benches for the trial lawyers, and he had blue and green on other places. And so the whole thing was festooned with all of this wonderful
That's a
stuff.
great story.
And then he was very stern and incredibly scrupulously fair as the presiding officer of the Senate. He annoyed the Jeffersonians because he was scrupulously fair, and they wanted him to act as a naked partisan. And the Federalists were like, he's our guy. We love them. Look at Burr. And Burr handled it with extraordinary gracefulness and professionalism. It was one of the great moments of his life. The fact that that's part of this story, it just makes it political theater in the highest sense of the term.
Moving on, I have failed you.
Oh, we have some things that we have to mention.
Last week we did not mention, and I'm afraid that you might have taken it personally, but there's a sort of a comedic event.
And here you go again with your snarky. I am doing
this.
What
do you mean? Wait till your daughter gets here.
You should have heard her response. I'm doing this one-man comedy hour, just stories from my life on the road as a guy who dresses up as historical characters.
I am quite certain it's going to be outstanding.
I gave a version of it up in Stanley, North Dakota the other day, and they were wetting their pants with happiness. But anyway, I'm doing a comedy monologue
and that will be
evening of stories
on
on February 25th at the Roper Theater in downtown Norfolk, Virginia. People should fly in from all over the country for this. If they don't, those who are nearby, the 25th of February, Roper Theater.
Gee, I hope somebody's going to record it.
It's a fundraiser for. Oh, it gets worse. Just wait. It's a fundraiser for our host station there, WHRO. But are they recording it? You bet. You know why? Because like William Shatner, I am producing an album. There's going to be an album based on this
I'm not sure Shatner's the best.
No, but it has
comparative example.
But it's that stupid is my point. And I'm doing this album, and my daughter thinks, oh, God, when it comes to when you're at the point in your career when you're going to do an album.
Maybe a Christmas record, huh?
Yeah, I think so.
I don't want to go there.
No, we could go back to our Fidelis, yeah. So that is the 25th of February in Norfolk, Virginia. I'm very excited about it. I don't care what you think because I don't like your attitude,
Go
frankly.
to jeffersonhour.com for more details.
And I want to fill that auditorium, and I think people are going to say, you know what? Swenson was a little unfair on this one. Yeah.
It's time for your essay, but before we go there, you gifted me the November 2019 issue of We Proceeded On, and I thank you.
It's the Lewis and Clark Quarterly Journal, which I edit.
Yeah,
and look at the cover.
Great articles.
There's Lewis collecting plants at Packer Meadows up west of Missoula, Montana. It's my favorite image of Lewis.
I honestly have been there.
Yeah, it's great, isn't it?
At the Meadows there, yeah.
And so he was collecting camas roots.
Sound recording of natural sounds.
There you are, ambient sounds. But anyway, so this is a quarterly journal of 36 pages, and it's a peer-reviewed journal. I hope people will subscribe. They can find out more on site. But also, that leads me to the Lewis and Clark Cultural Tour in the summer in late June. This will be the 18th time I have led it. It's my favorite week of the year. It's now open for booking. I urge people to consider coming. I think it's begins on the 12th of June. But in mid-June, out on the canoeing on the Lewis and Clark Trail and hiking the Wendover hike. It's
your favorite time of the year.
It is my very favorite thing I get to do with my career.
It is the time of year for us to wish everybody a happy holidays.
Happy holidays.
And then,
so that'll be on the album.
Yes. And then, sir, it is now time
Oh,
for
come,
this week's.
all ye faithful.
You're walking over me.
Yeah.
It's the time for this week's Jefferson Watch.
Thank you, everyone, and hark the herald. Here's why I love what I get to do. The national impeachment crisis over the presidential behavior of Donald Trump has turned us all back to our history books. I own, but have not yet read, several of the recently published books on impeachment, one with chapters by Peter Baker of the New York Times and John Meacham, America's latest favorite presidential historian. I would urge everyone who's listening to read one or more of those books. Impeachment is a grave constitutional remedy. We gain insights by looking at previous impeachments in American history. My now lifelong commitment to Thomas Jefferson gives me reason to take special interest in national events that otherwise might escape my notice. We are all busy. We don't have much time to read, and when we do, we tend to read things that give us pleasure rather than intellectual or moral pain. To get ready for today's program, I reread key chapters in several studies of Jefferson, David Mayer's The Constitutional Thought of Thomas Jefferson, and James F. Simon's excellent What Kind of Nation? Thomas Jefferson, John Marshall, and the Epic Struggle to Create a United States. Thomas Jefferson was involved in 2 impeachments of federal judges. The first was John Pickering of New Hampshire, an able and influential man, now unfortunately compromised by alcoholism, neglect of official duties, and even actual insanity. Pickering was impeached in 1803 and removed by the United States Senate. Even Jefferson realized that the constitutional remedy of impeachment was an extremely imprecise tool for what needed to be done here, because alcoholism and insanity do not constitute high crimes or misdemeanors. But it was clear that Pickering had to be removed, and impeachment was the only available remedy. He was convicted by the United States Senate on March 12, 1804, and removed from office. But here's the most important fact. The vote was on strictly party lines. All Federalists in the Senate voted to acquit, even though they knew Pickering was insane and could not really be trusted as a United States judge. Think of that. All Federalists, knowing that he must be removed, voted to acquit. So great was their disdain for Jefferson and the Republican majority. Then came the impeachment of Supreme Court Justice Samuel Chase. Here the Federalists were on much better ground. Chase was an angry, outspoken, abusive justice who harangued grand juries, bullied witnesses, gave anti-Jeffersonian lectures from the bench, engaged in questionable rulings, and generally turned his official judicial office into a bully pulpit from which to propound his anti-democratic opinions. He had made some rulings that were questionable from a legal and a judicial point of view. He had presided in a highly prejudiced way in the sedition trial of James Callender, who was first a Jefferson defender and later, as you know, a Jefferson hater. Callender was the man who broke the Sally Hemings story in September 1802, and tried to blackmail Jefferson into giving him a plum federal job. So Samuel Chase, a signer of the Declaration of Independence, was an obnoxious man, and he was certainly having a distorting impact on cases that came to his courtroom. But was that enough to impeach him? The answer is no. Even though Virginia Congressman John Randolph, an eccentric genius, went after Chase with every legal and rhetorical tool at his disposal, Chase was acquitted on each of the 8 charges leveled against him by the House of Representatives, even though the Republicans had enough senators to vote guilty on each of the counts. In other words, if there had been a strict party vote, Chase would have been removed. That would have set a precedent that might have altered the course of American judicial and political history. But enough Republican senators were wary of using impeachment as a political tool that they refused to evict Chase, whom they loathed as a vicious partisan bully. What does all of this tell us? First, the party in power has a harder time maintaining strict party discipline than the party in opposition, which is often nakedly partisan in its response, irrespective of the facts. If you won't vote to remove John Pickering, Whom will you ever remove? Second, the Founding Fathers gave us a very problematic impeachment clause. Pickering had not committed any high crimes or misdemeanors. The Founders did not provide a clear mechanism to get rid of an alcoholic, a person who was mentally ill, a person who had abused his office without committing a definable crime. We'd be much better off in a parliamentary system on these occasions. In that case, the Parliament, say a majority of both houses of Congress, would subject the executive to a vote of confidence or no confidence. If the executive lost the vote, he or she would be removed. This is how the British do things, and many other parliamentary democracies, and it works. Third, in each of these judicial impeachments, lawyers argued in a learned way about what constitutes an impeachable act. Lawyers for Samuel Chase insisted that he could only be impeached if he had committed an indictable crime. Lawyers for the prosecution argued that the impeachment clause had to have a wider application than that, or it was not a tool that could protect us from a tyrant who outraged the Constitution in all sorts of ways but did not commit a crime that had been defined by government. So what should we conclude from a study of the impeachments of the Jefferson administration between 1801 and 1809? The central conclusion one draws is that impeachment is a muddle. Jefferson himself called it a bungling way after the Pickering trial, which ended as he wanted it to end, but left a bad taste in many thoughtful senators' mouths, because Pickering was not a criminal. After 200 years, no matter what the constitutional scholars say, we don't really know what constitutes an impeachable act, because we have never had a successful impeachment of a president of the United States. Bill Clinton lied under oath. He perjured himself, and yet he was acquitted by the Senate. Donald Trump has done some dastardly things, but it seems inevitable that he will be acquitted by the Senate, and along strictly partisan lines among the Republicans, and along mostly partisan lines amongst the Democrats. And then where will we be? That will more or less kill the impeachment clause once and for all. In other words, the only way for us to preserve a Republican form of government will be if the president is evicted, whether or not you think he is bad enough to deserve removal. When impeachments inevitably fail because the party on the defense refuses to look at the charges in a purely constitutional manner, you may as well erase the impeachment clause altogether. Meanwhile, you have wasted the public's time and not addressed energy policy, immigration policy, health care, and global climate change. If a handful of Federalists had been willing to remove the insane alcoholic John Pickering, I would have some faith in the system. Perhaps the greatest takeaway from a historical survey like this is that naked partisanship is not something new in 2019. It has been the fundamental truth of the American political system from the very beginning. And to that, all I can say is, alas. I'm Clay Jenkinson. We'll see you next week for another exciting edition of the Thomas Jefferson Hour.
The Thomas Jefferson Hour is brought to you each week by Dakota Sky Education. The program is distributed nationally by Prairie Public. President Thomas Jefferson lived from 1743 to 1826, and this program presents his views. President Jefferson is portrayed by the award-winning humanities scholar and author Clay S. Jenkinson. To obtain a copy of this or any show for a $12 donation, please call 701-575-0727. This program is also available online at jeffersonhour.com and on Apple Podcasts. If you'd like to correspond with President Jefferson or submit a question for him to answer on the program, please visit the website at jeffersonhour.com. The Thomas Jefferson Hour is produced at Makoche Recording Studios in Bismarck, North Dakota. Bach Cello Suite No. 3 in C Major by Stephen Swinford. Thank you for listening. Please tune in again next week for another thought-provoking, historically accurate program, Through the Eyes of Thomas Jefferson.